Hi, we are talking about the important clauses that is required in a contract. This is very good for the interns, legal students, lawyers in the budding stage who are preparing a contract. So these are the important clauses that is required to have a complete contract, whether it could be a contract for services or products. First, obligations of the parties. You should define the obligations of each of the parties, including the terms and conditions that they agree upon. Then the contract price, which could be including the transportations, insurance, tax, duties. Then payment terms. Payment terms could be credit period, progressive payment, even letter of credit. Then risk, title, and insurance. Who carries the risk throughout the project completions? When is the title of the good transferred to the other party? Who takes up the insurance for the project or service or the delivery of the goods, like the contractor's risk, which is required for the huge construction projects, public liability insurance, workman compensations. Then we talk about the representations and warranties, whether the party is licensed to do this activity, what are the warranties that are provided for the goods and services. Performance bond. This is used especially for huge projects to secure the rights of the clients. Advance payment guarantee. When you release a payment without starting the project by the supplier or a contractor, you take advance payment guarantee. Then retention payment guarantee. When the project is completed, the clients usually keep a certain amount of payment as retention to secure their rights. Then indemnity, which is a very important clause in a contractor. This is a guarantee by one party that it will take care of the cost of certain challenges by the third parties who are in parties to the contract. Then confidentiality. This states that parties won't relieve the certain confidential information of the other party. Arbitration. Resolving a disagreement without legal action. This is a clause that can save legal fees for you because during a dispute, an independent arbitrator is available to look into disputes and decide compensation. Choice of law. This is the law of a chosen state applied to a lawsuit. Jurisdiction. This clause states what country and a state of lawsuit must abide by. Waiver. This is a right a party retains not to take legal action against the defaulting party while maintaining the right to do so should the other party default at some point. Severability. This means instead of terminating a contract, only removing the invalid clause or rendering unenforceable by a court while the unaffected parts of the contract stay intact. Integration. This is also known as an entire agreement clause. It states that the contract is a complete agreement of all contracting parties concerning the subject of the contract. Then we talk about the limitations on damage. This determines what kind of damages a contract is liable to award in case of a dispute. Amendment. This is a clause that protects parties from having a contract amended without their consent. It states that contract is only amendable only after the written consent of the affected parties. Then you could include the annexures, attachments, which means you could attach the technical specifications or the proposal of the parties, etc. So these are the important clauses that is required in a contract. There are much more. If you have any clarifications, please feel to contact us in the given details here.